Let's talk about the dreaded notice of intent to deny. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and our nation's capital, Washington, D.C. In this video, we're talking about the NOID, how to avoid the NOID, the notice of intent to deny. So, when you apply for any immigration benefit, sometimes the agency is not convinced. You have not met your burden. And remember, always, it's your burden to prove that you are eligible for the benefit sought. It is not the agency's job to figure out whether or not you deserve the benefit or whether you are eligible for the benefit. It is your job to demonstrate to the satisfaction of USCIS that you are eligible for the benefit sought. When the agency is not sure, when the agency feels that you have not submitted enough evidence in support of your application, they might send you a request for evidence. A request for evidence is not something that you want to get. It's going to slow things down, but it is an opportunity for you to give them what they're asking for or what you didn't submit the first time. And so requests for evidence are something that are sort of easily overcome. It might slow down your case a couple months. It's not great. It's not great to get a request for evidence. You're sort of bummed when you get it, especially if it's for something dumb like not submitting an I-130A or not submitting tax returns or tax transcripts or something sort of easy. You might get a request for evidence for more bona fide marriage evidence. You might get a request for evidence if you're applying for citizenship for a traffic ticket that you didn't provide documentation for. These are relatively minor things that can be overcome. But then we turn our attention to the notice of intent to deny. So, federal law requires that if USCIS is going to deny your case, they're supposed to, before they do that, send you a notice of intent to deny. They are supposed to alert you to the fact that they're strongly considering the fact of denying your case. They are inclined to deny it. In other words, right now we think your case is going down the drain. We think your case is not going to be approved. We're going to give you one last chance. We're going to point out to you what's wrong with your case. We're going to point out to you in writing why we think your application is defective. We've already told you in a request for evidence, most likely, that you have some problems with your case and you still haven't fixed it. It's sort of like your second chance, or more accurately, your last chance to convince us that what you want is what you're entitled to. And the way that they do that is by sending you the NOID, the Notice of Intent to Deny. And this, like I said, is your last chance. So you need to take this very seriously. I've seen a lot of NOIDs where people are told by USCIS, we asked you in your request for evidence for XYZ, and you sent us stuff that you already sent us. You did not send us what we asked for. Now, sometimes requests for evidence are confusing and not very well written. But in the notice of intent to deny, they're going to say, you applied for naturalization or you applied for a green card. And you're doing that based on marriage or based on asylum or whatever, diversity visa or employment. And we think that there's some legal impediment, some reason why you are not eligible to adjust your status to lawful permanent resident, or you're not eligible to become a U.S. citizen at this time. We're going to give you this one last shot to save your case, to save the filing fees, to save all the time that you've invested into this particular filing, and sort of resurrect your case from the dead. Now, I believe, in all honesty, that if your case has received a notice of intent to deny, most likely you don't know what you're doing. Most likely you should have had a lawyer helping you from the get-go. But at the very least, now that your case is on life support, you most definitely need help. You're not doing it right. You're missing something. You've not given them what they want. And I would say that, I don't know this for a fact, but I would say that most cases in which a NOID is issued and a lawyer is not involved are going to end up in a denial. So, sometimes we see notices of intent to deny and we say, look, this thing can't be saved. You fundamentally screwed up. You filed for citizenship too early. You filed for your 10-year green card too early, whatever it is. But most of the times we can mount a good response to the notice of intent to deny. Most of the time we can spot the issues. I spend time almost every day looking at NOIDs that people received, and I've come to see some patterns. One is that usually the people are overwhelmed. They are missing the point from USCIS. They don't know what their burden is. They don't know what evidence USCIS typically likes to receive in order to overcome a particular issue. So I would posit that everybody who receives a notice of intent to deny needs a lawyer. I think that if you've been messing around with the case for this long, you've probably made it much harder than it needed to be. You probably put your case on a slow track to nowhere. You've probably really messed things up, which might even make it harder for a second application. So you've got a lot riding on that NOID response. You need to win at this stage. Otherwise, you're starting over. You're paying for everything all over again. I'm going to charge you more because you have a prior denial. It's just a big old mess from start to finish. So I beg you, if you receive a notice of intent to deny, call me or some other attorney, have them look at your NOID and have them explain to you why you need legal help, an immigration lawyer, somebody who does this every day, to put together the strongest response possible to that notice of intent to deny. I can't say it any better than that. I hope that you consider hiring us if you are working on a case. I would encourage you to hire us at the beginning so that we don't get a request for evidence, so that we don't get a notice of intent to deny. That's always the goal. Streamline the case. The agency's already slow enough. They're already taking too long to decide cases. And so if you're adding to that delay by filing stupid stuff, by not responding to a request for evidence, by not giving them what they want in response to a notice of intent to deny, you're really setting yourself up for a lot of frustration and failure. So we'd love to work with you on it. 314-961-8200. Email us info@hackingimmigrationlaw.com. Be sure to join us. We have a Facebook group. There's thousands of members in there, almost 15,000, talking about the immigration process and what it takes. We also have our YouTube channel. You can subscribe to that. You can see all the videos that we've posted, hundreds and hundreds of videos. We also do an Immigration Answers live show 3 or 4 times a week. That's just me answering questions from immigrants. We'd love to have you ask us your questions and to join our community there. If you want to get in the waiting room to ask me a question one day and to get an alert as to when we're going to go live, text the word SHOW, SHOW, to 314-470-3300. And finally, we have our TikTok channel @Immigration Hacking. Please join us there, and we'll see you next time.